You've lived a great life and done well for yourself. But what mark will you leave on the world? How will you inspire future generations? Stan Miller and Katie Beth Hand have helped thousands of people answer exactly those questions. If you've ever wondered, what will be my legacy? You're in the right place. Welcome to the Your Life, Your Legacy podcast. Now, here are your hosts, Stan and Katie Beth.
Welcome to the Legacy Leaders podcast. I'm your guest host, Rod Hatley of Hatley Law Group here in San Diego. And today I have the pleasure to speak with a colleague of mine, Dustin Nichols of Dustin Nichols APC, based in Newport Beach, California. Dustin, welcome to the program.
Rod, thanks for having me, and it's certainly a pleasure to be here.
So let's go ahead and jump right into it. You're an attorney and you focus in the areas of estate planning and also asset protection. Can you briefly explain what asset protection using exemption planning is? I know that's something that you specialize in, and I know it can be very valuable for your clients. And can you talk a little bit about that and help the listeners understand what that's all about and how it can be valuable for folks who live in California?
Absolutely. It's probably a good idea. Just take a step back for a second and kind of set out the legal landscape that exists for California residents. As it stands right now, I think there's 40 million lawsuits that are filed in the United States annually.
Wow.
65% of those lawsuits are filed in New York and California.
My goodness.
California has the esteemed nation as being one of the top 3 judicial hellholes in the United.
My goodness.
We used to be number 1, but now we lost it to a couple of others, so now we're number 3. But still, it's a choppy place to live if it's an issue of trying to protect yourself. California also has legislation that's helped to achieve that number 3 ranking, including AB 5, which is that legislation basically makes everybody and their dog an employee. Here in California, big companies like trucking companies are struggling now with potential PAGA claims, with wage and hour lawsuits that are coming at them. There's potential personal liability. So it's a choppy, tumultuous legal climate in California. And business owners are always looking for ways to effectively try and protect themselves. And unlike a lot of the other asset protection strategies and schemes that exist, exemptions are always your number 1 first line of defense. And it doesn't matter what state you live in. But in some states, obviously, these exemption statutes, these are statutes that the legislature in their infinite wisdom create that carve off limitations and also protections against certain categories of assets. California doesn't exactly have the most robust exemptions, but it does have a new enhanced homestead.
Yes, it does.
It used to be a small 75,000 individual, 100,000 for married couple, 175 if you were a senior over 65 or disabled. Now it's a minimum of 300, maximum of 600, depending on the county you live in. And the median sale price of a single family home from the year before, adjusted for inflation. So it's a county by county analysis, but it's a lot better than it certainly was before. And here in Orange County, I think the new exemption is $678,387 adjusted for inflation. So there's a nice chunk of equity you can now rely on. And if you haven't impaired it, in other words, you have a loan that's on it encumbering that equity or impairing that homestead, then you've got a nice little chunk of equity there that's at least protected against money judgments. Right. But there are other exemptions, and we're going to talk a little bit more about those in a little bit. One specifically that protects California's right to their private retirement.
Okay. And what are the common risks and threats to personal and business assets that people should be aware of?
Sure. There's really 2 types of liability, especially for business owners. There's inside liability and there's outside liability. Inside liability is the liability inside the company, right? That is inherently that those assets are subject to those liabilities in the business. So whatever the company owns and its value, that's always something that's by way of a concern and that worthy of some additional planning and some thought. But also outside of that is, well, what you've acquired individually, personally, from all of your efforts over the years, your vacation homes, your marketable securities, your real estate. There's all kinds of outside assets that you want to have protections against. Right. Umbrella insurance is great, but the problem with umbrella insurance is that it doesn't cover a lot of things, including intentional wrongs, criminal restitution. If you let somebody borrow your ATV, then they get in an accident, it's not listed on the policy. There's lots of those exclusions, but insurance is great for two things. One, creating a legal defense fund that'll help pay your defense so you're not writing checks to your lawyers to defend you. And then obviously a pot of money to help, settle with a creditor. Sure. And obviously the planning you do on your personal balance, around your personal balance sheet, is going to make that more likely to happen than not, because creditors, especially if they're huge judgments. So for instance, if there's a huge outside liability, you personally, or you get in a catastrophic accident, right, then you're going to want to have something in place to help protect yourself against those, right, those potential exposures.
Okay, well, thank you for clarifying that. Can you share with the listeners what are the legal methods or strategies that are available for exemption planning here in California?
Yeah, first, it's always you want to maximize all of your current exemptions. So like I mentioned earlier, making sure your homestead exemption is not impaired, and looking at some of the other little exemptions. But the PRT, the private retirement trust, that's based upon the private retirement plan exemption, is a huge opportunity for business to recharacterize otherwise exposed personal retirement assets they're looking to sustain and maintain their lifestyle through retirement, to be able to recharacterize those as exempt retirement assets over on the other side. And so that, in my opinion, and I've devoted pretty much the last 10 years of my life perfecting a platform that can capture and maximize this particular exemption, I think it's the most effective. Now, obviously, other traditional methods are still build on top of that are important. LLCs, limited partnerships, sure, using irrevocable trusts, other things in traditional estate planning before any problems have come down the pipe. Those are obviously all in play as well. But I think, that ultimately your first line of defense beyond the insurance are exemptions. And so to overlook those, to not maximize those, is shortchanging your ability to effectively protect yourself.
Well, the question I've got is, are there particular ones that you specialize in or would recommend? I mean, you may have hinted at it with the private retirement trust, but is there anything else perhaps that you focus on?
No, those are my primary. The PRT is my primary focus here at the firm. Again, it's specific only to California. So me being a California lawyer, that puts me right smack dab in the middle of where it's most useful, sure, and advantageous. And so that's pretty much what I focus my practice on.
Okay. Well, let's say, how can an individual or a business owner assess their specific asset protection needs? I mean, obviously, that's really where you excel. But how would someone who's listening to this podcast make that assessment or that determination? I probably ought to talk to someone like Dustin, so they can make sure that
you talk to Justin too, if you like.
Okay. To make sure that they're not missing opportunities to protect themselves.
Yeah, no, absolutely. I've always been a big fan of due diligence. I was formerly a partner over at Brown and Streza for a few years, and very heavy in due diligence. And I think that's really where you start. And I call it the phase one PR2 diligence engagement. And that's where we take in all the data, their financial information, and not to ignore the facts and circumstances surrounding them at the time that they're looking at doing some planning, whether there are any claims that are either pending, threatened, or expected. And we do a full vetting on those, because in some cases, with doctors, they may have 3 or 4 lawsuits against them at all times.
Oh, wow.
That doesn't mean that they can't plan. And a lot of the cases, they're just named because they're part of the doctor group, right? And they didn't actually see the patient. But because they're a defendant, well, there's a claim. Right. So we evaluate those, and using a 1988 bankruptcy court case called In Re Zonix, which is persuasive. It's not mandatory authority, but it's very helpful. And I think it's useful to help establish what we call a contingent liability. So to the extent that there is a potential contingent liability, then we make sure we set aside those assets. Why? So we can thwart any allegation of intent to defraud.
Right.
This is one of the 5 tests under Uniform Voidable Transactions Act. And we get hired, actually, believe it or not, by other bankruptcy firms that have clients that have done asset protection plans
Okay.
to review those to see if we had to take them into court, how they might fare in front
Sure.
of the judge, right? And interestingly enough, there's a lot of detail that sometimes gets overlooked.
Oh, yeah, no doubt.
Consideration, no respecting of corporate formalities, no bank accounts inside the entities. And that's not to say that all of them are like that, but there's a big chunk of them done by folks that probably didn't pay the necessary attention to those details. And we want to make sure that we isolate and highlight that so clients don't find themselves in worse situations than had they had done nothing at all, right?
Sure.
So phase 1 is real important to get our arms around everything that's there, everything that's been done, understanding what, again, the total facts and circumstances, because ultimately clients got to walk into this solvent, right?
Yeah.
And if there's something out there that tips that solvency, that's another test that we just violate and put a creditor in a good position to succeed against that client. So phase 1, that due diligence imperative to really getting and setting the landscape for ourselves to plan going forward. Whether we decide to do so, I've had to turn away engagements because, that was close. Other ones, look, they're small contingent liabilities. Great. We set that and those amounts aside and we plan around it for that client's retirement.
Can you share any real life examples or case studies where exemption planning made a significant impact for your clients?
Oh, absolutely. In fact, one of the first cases that I went to court on had to do with an elderly gentleman, 70 years old, that owned a electric service company, was one of the exclusive contractors that serviced the school districts around the state of California, had a lot of subs, been very successful, 50 years in business, came to me to do some estate planning 20 years ago. And I was able to get some basic stuff in place, but he was a procrastinator and he really didn't see any need to do any additional planning. He was one of those guys, I pay my bills, I resolve my differences, everyone loves me, I pay my taxes. What could go wrong? Well, that's the unknowns that get people, not the things that we know and think about, the risks that we identify that ultimately wind up trying to bite us. It's the stuff we don't know about yet. And that's what I try to get out by way of a message is don't plan for the things necessarily you think are going to happen.
Yeah.
Plan for the ones you don't know that are ultimately going to potentially bite you and want to be prepared. Right. So in this individual's case, he was paid by the school district, by the school district through the state. And the state budget crisis started way back in, I think it was 2013, 2014. This individual kind of felt the writing on the wall because he wasn't getting paid, but yet it was still viable, still working. But he said, I'm a little concerned. I better do something. And he did a PRT with me, actually one of the first ones I ever did.
Wow.
And we were able to justify putting into his plan about $3 million. Wow. Part of it included the sale proceeds of his home. His wife had passed away and he got remarried and wanted to sell his big place and wound up buying a smaller place, but by actually putting money into the PRT and borrowing it out a year and 2 days after we created the plan, and fully secured by a deed of trust with commercially reasonable terms and blah, blah, blah. Again, at this point, we didn't know what was coming to the extent of what happened. And what happened was a couple of years went by and he had to put his company into a Chapter 11 because the subs were biting at his heels, saying we need to get paid, and the state wasn't paying him. And he said, well, all right, I hope I'll be able to reorganize my company. And the two things you need to reorganize under Chapter 11 are you need to be able to show that the creditors are going to get more than they would have got had you filed a 7 liquidation. Right. And that it was feasible, meaning that you could make some kind of a plan payment to the creditors.
Okay.
In this case, he couldn't do number 2 because the state still wasn't paying. And so the bankruptcy trustee converted his Chapter 11 on a motion to convert to a Chapter 7 liquidation. What that did, no one saw this coming, was trigger the withdrawal liability that existed under the collective bargaining agreements with the Electrical Contractors Union, backed by the Department of Justice. They bankrolled this. And when that happened, who knew this was coming? because he owned the business or the property that his business ran on under the MPAA rules, ERISA law,
Right.
became personally liable for the full amount of the withdrawal liability, which was over $2 million.
Oh my goodness.
And so here he is. He's 70 years old. He's got COPD. He can barely breathe. We did a 3-year plan, which is well under the term that I would like to do, would feel comfortable doing.
Right.
But for him, because of his age and where we needed to get to be able to maintain and sustain his retirement need, we advance funded a lot of that. Ultimately, on the eve of a summary judgment motion brought by the Electrical Contractors Union, he had to file for a personal bankruptcy.
Okay.
And he did. And when we scheduled the PRT, not as an exempt asset, but as excluded. And why is that? Because of I'm going to get too technical, but there's the way we built the PRT, it has certain anti-alienation provisions. Now, the client didn't have direct control. This is why they don't have direct control over their PRT. We have an independent trustee, licensed and insured. Because of that, and those anti-alienation provisions, it's considered a excluded asset, not an asset subject to the bankruptcy estate when he filed.
Sure.
Which created a lot more opportunity at that point. The PRT actually acted in a large capacity as a defense fund, otherwise wouldn't have been available. And we went to court, and the bankruptcy trustee and creditor, they couldn't figure out how to attack it very well. It's not something I think that they've readily seen too often. The point being is, you have to attack the PRT in bankruptcy, you have to file what's called an objection to the claim of exemption within 30 days of the conclusion of the 341A hearing, which is a meeting of the creditors.
Right.
And they couldn't figure out how to attack it, so they continued the 341A hearing 28 times.
Oh, wow.
Ultimately, Judge Smith down in Orange County, she's since retired. She was a great judge. She finally said, it's time to put up or shut up. It's taking too much. And we got a favorable ruling, and it went to, she ordered us, there were some open items. She sent us to mediation. And what it did was it created the right environment for a settlement that otherwise didn't exist when the other side thought that they could just roll over you. Yeah. In this case, it was even sad because the client wound up passing away right in the middle of the bankruptcy. So the executor became the substituted debtor to finish. But here's the bottom line: is the two heirs that stood to basically get nothing.
Right.
If we weren't successful, wound up getting a sizable inheritance.
Fabulous.
And passed pursuant to the estate planning that we did for the client. So, in my opinion, that was a big win. Whenever you can create something that puts up enough legal justification to push back, then you've got something, and that doesn't exist in a lot of other areas, especially when we're talking about protection, right? Now, the PRT has to be primarily purposed for retirement. So we ultimately made sure that was very clear in the paperwork and the surrounding analytics and the insolvency affidavit. And when I went to mediation at Adjudicate West, to ultimately settle this claim, the judge asked me, the first question was the client solvent when he entered into this transaction? Out comes our solvency affidavit. Out comes the net worth statement that attaches to it. Out comes the full disclosure and due diligence findings of the lawsuit that has existed at the time that we created it in all of our defenses. And interestingly enough, the mediator, he turned to me and he said, "Where do I get one of these?" I knew at that point, that what we were working with had some real valid underpinnings, and that it was worth spending more time developing and creating something that could be offered in a larger scale to the wealthy business owner clients here in California.
What are some of the most common mistakes that people make when they attempt to protect assets and they don't hire an attorney to do it? And I'm sure you've seen horror stories, but I just want to understand what you've seen, because I think it would help the listeners. I realize that they really shouldn't try to do this on their own. They really need the help of a professional.
Yeah, gosh, I don't even know where to start.
Yeah.
What I see most often that really is sad as well as concerning is people that try to put their homes in LLCs, thinking their principal residences, thinking that they're going to protect them, only to find out that all they've done is impair their homestead exemption. They lost it. And they lose the 121 exclusion that they get from capital gains on sale too.
Oh, no.
And so it's like what they thought they were doing was great, but they didn't check with the lawyer.
Yeah.
They didn't really do the research necessary to see if what I'm doing is going to hurt me more than help me. And that's the theme. There's a lot of folks out there that look, they want to do something to help themselves. And self-help is great, but I wouldn't go and perform my own open heart surgery. And so I wouldn't recommend anybody that isn't, not even lawyers for the most part, understand this area of law unless they've been immersed in it.
Of course.
For years. There's a lot of so-called asset protection lawyers that you don't have to get a certification from the bar to call yourself one, right? But it's really about experience and understanding and knowledge in the areas beyond just setting up a trust. Really knowing, because ultimately at the end of the day, it's the bankruptcy lawyer that's going to have to take whatever you have,
Right.
Try to defend it or not, because they're the attorney of last resort. And
right.
A lot of workouts can be very successful utilizing good bankruptcy lawyers if you get to that point where there's that catastrophic event, either in business or personal, that creates potential for a large liability. And you want to be able to have the tools to give to the attorney, the bankruptcy lawyer, to go in and do their job to get you out with the least amount of pain and expense.
Okay. Share with our listeners the type of client that can really benefit from exemption planning here in California, and when should they be seeking assistance from a professional like yourself?
Well, the answer to that is as soon as possible.
Okay.
You don't wait for something to happen, to try and do something. That's the worst scenario under any circumstances. But I've had clients who called me that have lower net worths and they're just trying to preserve things like their home.
Right.
And they have a mortgage, and it's very traditional in pre-bankruptcy planning to pay down mortgages to open up and free up your homestead exemption, say, for instance, right? That's when stuff's already gone on, or even not. If what you're really trying to do is, again, maximize those exemptions, then you could do that ahead of time too. You're just being smart about how you impair your homestead. But, for those that want to do a little bit more and protect a lot more, and they're the right candidate. In other words, there's nothing going on around them that's catastrophic that we can justify doing some retirement planning, then the PRT is a really great choice. And folks that are the ideal candidates for that type of planning, for the integrated exemption planning, using this retirement exemption, are folks that are $5 million in net worth and above, making more than $250,000, and have a horizon to retirement for more than 5 years. We do a minimum 5-year plan, and because it's non-qualified, non-ERISA, you're not subject to the rules, restrictions, prohibitions, and penalties. So you can set your retirement age lower. It doesn't have 65. We don't have RMDs. We don't have to worry about the required minimum distributions and things like in the ages relevant to those. And so it really does create more of a flexible environment to take advantage of a very potent tool available to California business owners and residents.
Let's see, how do you approach each client's situation? Obviously, every client is unique, and I'm sure there's not a one-size-fits-all approach to this, but can you share with the listeners, how do you approach each client when they talk to you and they want to retain your services to use the exemption planning to protect assets, et cetera?
Sure. Well, first I offer a free 30-minute consultation. Okay. I show them what I call what I've dubbed as the PRT 6-slide primer. And so we'll get on a Zoom call and I'll show my 6 slides, explain the underpinnings, what exemptions are, how they differ from other things in the protection world, and drill down on specifically the private retirement plan statute and how the trust works, what kind of assets are appropriate in funding matrices, and then go through the steps, which we talked about a little bit already. Phase, if it's something of interest to them and they want to move forward, we'll go through phase 1, our PRT due diligence engagement. And then we'll figure out if they're good candidates, give them an opportunity to ask all the right questions, bring in their advisors, educate them, including their financial advisors, because we obviously want to work in concert in a very team-oriented approach. The days of being an island and planning for a client are over, have been for a while, but even more important now that we integrate. So we go through all that, and of course, and then vet out any claims that are pending, threatened, or expected. We get through phase one, and we implement. We go into phase two. And that means we've already determined they're good candidates. Clients they're educated on it, and they feel comfortable in moving forward with it. And phase two is creating and implementing, and that's where we bring in our retirement appraiser to do a formal deep dive into their retirement need, including cash flow analysis. So we understand exactly what it is we have to work with. We don't want to impair a client's lifestyle. We want them to be able to live like they ordinarily do, but at the same time, take the fat off the table and move it into that protected locker, right? So that it's there and will continue to grow in that protected environment to ensure that their retirement need is met. And that retirement need, the money that we've justified and the assets we've justified to go into that is protected under the statute. The distributions that come out at retirement age are also protected and should be set aside separately in a separate distribution account, so as not to commingle it with non-exempt assets.
Okay.
And the death benefit too, as we talked about. And then we have to maintain these. And so the company, just to kind of point out, this is employer sponsored. You have to be an employee of your company. You can be your own company. The company pays for everything. It's all tax deductible.
Okay.
But the company also hires our administrative service, retirement exemption administrators, to administer, basically as the support service for our trustee, our tax accountants, and things that file the returns for the PRT. So there is an ongoing maintenance and sustaining of the plan. And it's not static. We meet once a year and we check Engage to see if there's any changes. If you're making more money, you've acquired more assets, it's possible to re-gear the plan to accommodate that additional, because you'll need to, right? Nothing's static. If nothing changed, we don't need to do anything at all. But maintaining these are very important. We just don't hand off binders and say, have a nice life. For this to work,
Sure.
You got to maintain them.
Got it. And I guess the last question for our time today, are there any specific industries or professions that face higher asset protection risks, and what steps can they take to mitigate those?
No, absolutely. The obvious professions that stand out are doctors, lawyers, architects, construction companies and business owners, financial advisors, wealth managers, real estate developers, trucking industries, trucking companies, if you will. Anything that has an inherent high risk profile are the obvious choices. But I don't think there's a business owner out there that frankly couldn't benefit from it.
Sure.
Simply because, again, it's the unknowns that come and bite you. It's not the stuff that you really plan for and think about.
Right.
But, just to kind of highlight a real fact pattern that wound up being the essence of the introduction of my article that I wrote and published for the Orange County Lawyer magazine in June this year.
Sure.
It was a gentleman who called me, who used to be an ex-manager of a very famous rock band. And he had amassed a nice little $8 million purse for himself that he called his retirement. That wasn't in any particular protected wrapper. It was just in brokerage accounts. And he had an autistic son that he was taking care of, 70 years old. He has a wife that had cancer that he obviously was trying to treat and take care of. And he left the music business, became a professional diver, was inducted in the Professional Divers Hall of Fame, and was under contract with the Cayman Islands, the Bahamas, to provide instruction to their diving industry on safety practices, best practices, and so forth. And he was driving down the freeway up by his home up in Northern California, and he was he was a second lane over, trying to get off the freeway. And he saw his exit coming, and he looked and he didn't see anybody. He went to go change lanes and wham, a lady on a motorcycle, 38 years old, Microsoft executive making $750,000 a year, single mom, 2 kids, 6 and 10, slams into the back of him and dies instantly.
Oh my goodness.
Now that could happen to anybody, you or me, our neighbors. It's just not something we think about. And that just obviously set the ball in motion for a lot of catastrophic things to follow. He called me and he said, I need a PRT. I told him, like, cat's out of the bag, the toothpaste out of the tube. I don't know how else to say it, but that's so catastrophic. You're looking at a $30 million judgment. Didn't have any insurance. He had $300,000 of automobile coverage. So ultimately, guess what? The next thing is, well, let's take a look at what you have, what's exempt and what's not. Thankfully, he had his house paid off and he lived in a county where he got the full exemption.
Okay.
But that $8 million is gone.
Oh my goodness. I'm sure sorry to hear that.
Yeah.
Justin, how can, I'm sorry, I keep calling you Justin, Dustin, how can the listeners contact you? What's your contact information?
Sure. Well, I'm located at 5120 Birch Street, Suite 100 in Newport Beach. My email is Dustin Nichols, ESQ @dynapc.com. So that's spelled DustinNicholsESQ @DINAPC.com. Phone number here at the office is 949-240-1101. Those are our main contact details. In our website, which should be up in a few weeks, it will be under www.dinapc.com.
Thanks for listening. This has been Legacy Leaders Podcast with your guest host, Rod Hatley, interviewing Dustin Nichols of Dustin I. Nichols APC in Newport Beach, California. And we will put his contact information in the notes, and we'll also link it to the show notes for those of you who are listening. Thank you so much for sharing the time. Dustin, a real pleasure to speak to you about exemption planning and how it can be helpful for listeners out there. Thanks again.
Absolute pleasure to be here, and you're more than welcome. Thank you.
Thanks for listening to the Your Life, Your Legacy podcast with Stan Miller and Katie Beth Hand. If you enjoyed the show, please rate, review, and subscribe on Apple Podcasts, Spotify, or wherever you get your podcasts. To find out more about Stan and Katie Beth, go to pinnaclelegacylaw.com. You can also find links in the show notes.